Keep your hands where I can see them.
My hands are on the wheel, officer.
We received a report about a suspicious vehicle. What are you doing in this area?
This vehicle is federally assigned. I'm Judge Marcus Ellington, United States District
I don't care who you claim to be. Produce your license. Step out of the vehicle
Officer,
now.
I am not resisting. My hands are visible and this vehicle can be verified immediately.
Judge Marcus Ellington had been on the bench since 7:47 that morning. Not because court was in session, it wasn't, not until 9, but because that was simply who he was. He arrived early, read through case files with a yellow legal pad at his elbow, and let the quiet of an empty courtroom settle around him like armor before the day's battles began. The courtroom on the 4th floor of the federal building was his cathedral, and he treated it accordingly. Every ruling he issued from that elevated bench was, in his mind, a debt he owed to the Constitution, not to politics, not to public opinion, not to the color of the parties standing before him. Just the law applied with the same unforgiving precision every single time. That morning, he had presided over the final arguments in a Section 1983 civil rights case. A young man from Overtown who alleged that officers had entered his home without a warrant, destroyed his property, and left without so much as an arrest. Ellington had listened to both sides with his signature stillness, his face giving nothing away, his eyes moving slowly between attorneys like a man who had heard every version of every story and was still, somehow, paying full attention. When he finally spoke, the courtroom went quiet, the way courtrooms do when everyone in them understands that what is being said matters. The Fourth Amendment, he told the room, is not a courtesy. It is a guarantee. And this court will treat it as one. He broke for lunch at 12:15. He was back on the bench by 1 o'clock. Daniel Harrow started his shift at noon. He pulled out of the precinct lot in a black and white with a large gas station coffee in one hand and a phone call from his union rep in the other. Something about the latest complaint, something about paperwork, something Harrow had already decided wasn't worth his full attention. He'd heard it before. 14 times, he'd heard it before. And 14 times, nothing had changed. That track record had not made him more careful. If anything, it had made him bolder, the way impunity always does. By 3 p.m., he was running pretextual plate checks on cars that simply looked, to him, like they didn't belong. By 4, he had pulled over a man for drifting, a stop that lasted 9 minutes and produced no citation, no warning, and no explanation beyond Harrow's instinct that something was off. The man was black, as the neighborhood was quiet and wealthy. The math, for Harrow, was always that simple. By 5:30, he had turned onto the tree-lined corridor that cut through the south end of the courthouse district. The palms on either side threw long shadows across the asphalt. Traffic was light, the evening was still, and then he saw it, a black SUV moving carefully through the intersection ahead. Government plates, tinted windows, a black man behind the wheel in a dark suit. Harrow reached for his lights. The call had come in at 4:52 p.m. Dispatch logged it as a suspicious vehicle report. A vague two-sentence tip from an anonymous caller who described a dark SUV driving slowly through the Palmetto Ridge corridor. No plate number, no description of the driver beyond an implication so thinly veiled that even the dispatcher had paused before logging it. The caller said the vehicle looked out of place. That was the entirety of the justification. 4 words: out of place. In a department with cleaner instincts, the call would have been noted and forgotten. Patrol cars had more pressing demands than chasing anonymous impressions. But Harrow had been monitoring the channel, and those 4 words landed on him the way a match lands on dry grass. He was already in the area, he was already looking, and now he had something he could point to later. Something he could write into a report, something that would transform what was really a hunch into what looked, and on paper, like a lawful investigative stop. This was the machinery he had learned to operate over 8 years. Not the law itself, but its language. The way suspicious vehicle could mean everything or nothing, depending on who was writing the report. The way officer discretion could be stretched like taffy to cover almost any decision, as long as the right words appeared in the right order on a form filed after the fact. Harrow was not unintelligent. That was, perhaps, the most troubling part. He knew exactly what he was doing, and he had done it enough times to know that the paperwork would hold. What the anonymous caller had not provided, and what Harrow never sought, was any actual evidence of wrongdoing. No erratic driving, no traffic violation, no reason to believe the vehicle's occupant had committed, was committing, or was about to commit any crime. The SUV was simply moving through a neighborhood that Harrow, in by some unwritten calculus he would never put into words, had decided belonged to a certain kind of person, and a black man in a dark suit behind the wheel of a premium, unmarked government vehicle did not match that calculus. He ran the plates at 5:38 p.m. The return came back clean, registered to a federal agency, which should have ended the inquiry entirely. In a functioning system, those 3 letters on a registration return, GOV, were not an invitation. They were a stop sign. But Harrow read the return, set his radio down, and kept driving. He would later claim in his incident report that he had been unable to confirm the registration before initiating the stop. The MDT logs, however, told a different story. The confirmation had come through clean, complete, and unambiguous 7 full minutes before he activated his overhead lights. He knew who he was looking for. He just needed the car to catch up to the story he had already written in his head. By 5:42, he found it. Ellington saw the lights before he heard the siren, blue and red strobing in his rearview mirror, cutting through the early evening gold like a distress signal. He checked his speed, under the limit. He checked his lane, clean. He felt, in the space of perhaps 2 seconds, the particular calculus that every black man in America learns to run automatically. The quiet, exhausting audit of one's own innocence that should never be necessary and always is. Then he pulled over. I put the SUV in park and placed both hands on the steering wheel where they could be seen. That detail would matter later. It always does. Harrow approached from the driver's side with his hand already resting on his belt, his posture carrying the particular tension of a man who has already decided how this encounter ends before it has begun. When he reached the window, Ellington was looking directly at him, not defiantly, not fearfully, but with a steadiness that seemed to unsettle Harrow more than either of those things would have. The bodycam footage, which would later be played in a federal courtroom to an audience that included 3 sitting judges and a jury of 12, captured that look with brutal clarity. A man in a dark suit, both hands visible on the wheel, his expression the precise, controlled neutrality of someone who has spent 19 years making decisions that could not afford to be emotional. Harrow wanted a reaction. He got composure, and composure to a man like Harrow read as provocation. License and registration. Now. Not a question. The first word out of his mouth was an order, delivered to a federal judge, the way you might address someone you had already decided was guilty of something, even if you hadn't yet determined what. Ellington complied without hesitation, yet reaching slowly and deliberately into his breast pocket and producing his credentials. Not just his driver's license, but his federal judicial identification, the card that bore the seal of the United States District Court and left very little room for ambiguity about who he was. Harrow looked at it the way a man looks at something he doesn't want to believe. Then he handed it back. Step out of the vehicle. Ellington did not raise his voice. He did not argue. He simply continued to exist in that preternatural stillness, explaining calmly that the vehicle was registered to the Department of Justice, that he was a sitting federal judge, and that he would appreciate Harrow calling his supervisor before this went any further. Each sentence was measured. Each sentence was, the body cam would confirm, entirely reasonable. And each sentence made Harrow angrier. Because Harrow had a script for this stop, and Ellington wasn't following it. There was no panic, no stammering, no nervous hands fumbling through a glove compartment. There was only a man who looked back at him from the driver's seat like someone who already knew exactly how this story was going to end. He was right. Before we go further, drop a comment right now and tell me where you're watching from. Your country, your city, wherever you are. And if you believe that no one, not even a badge, is above the law, hit that subscribe button. Because this story is just getting started. The judicial identification card issued by the United States District Court is not a simple document. It bears a holographic seal, an embedded security strip, a federal court designation, a photograph, and a signature block that includes the judge's appointment date and circuit assignment. It is, in other words, not the kind of thing a person fabricates on short notice, or at all, given that counterfeiting federal credentials carries its own significant criminal penalties. Any officer with 8 years on the force and access to a basic law enforcement database would have known this. Harrow knew this. He looked at the card for 11 seconds. The body cam footage would later allow investigators to count them. 11 seconds of silence while he held a federal judicial credential in his hand, the late afternoon sun catching the holographic seal, the United States District Court letterhead plainly visible to anyone standing close enough to read it. Then he flipped it over once, the way a man handles something he has decided to distrust on principle, and tossed it back through the open window onto Ellington's lap. "These are good," he said. "High quality, I'll give you that." The implication hung in the air between them like something toxic. Not an accusation delivered with any legal framework. Not a request for verification through proper channels. Just a declaration, informal, contemptuous, and final, that the credentials of a sitting federal judge were, in Harrow's estimation, a prop. A costume piece. Something purchased, perhaps, from the same place people bought novelty badges and replica uniforms for Halloween. Ellington looked down at the card on his lap. Then he looked back up at Harrow. His expression did not change. He asked, again, quietly and without theatre, in that Harrow contact his supervisor or run the vehicle's federal registration through dispatch. Both requests were entirely reasonable. Both requests were, under the circumstances, the absolute minimum that professional conduct required. Either one would have taken less than 3 minutes and ended the encounter before it could become the catastrophe it was already becoming. Harrow declined both. What he did instead was take a half step back from the window and adopt the wide stance of a man preparing to escalate. Weight shifted, shoulders squared, one hand returning to his belt. The body language of someone who had made a decision and was now committed to it regardless of what the evidence said. This was no longer about a suspicious vehicle or an anonymous 911 call. It had become, in the compressed and distorted logic of Harrow's ego, a matter of authority. His authority, the authority of the badge on his chest over the credentials on Ellington's lap. He had decided the judge was lying. And having decided it, no amount of documentation, no federal seal, no government registration, no calm and measured truth delivered from the driver's seat of an unmarked DOJ vehicle was going to change that. The truth, for Daniel Harrow, was simply whatever he chose to believe. And right now, he chose not to believe any of it. And 2 patrol cars arrived within 4 minutes of Harrow's backup request. Officers Trent Mullins and Chris Delaney, 6 years and 11 years on the force respectively, pulled up behind the unmarked SUV with the casual energy of men responding to something they had already been briefed on, already categorized, already found amusing. Harrow met them at the rear of the SUV before they reached the window, and what passed between the 3 of them in those 30 seconds, captured in fragmented audio on 2 separate body cams, would later be described by the DOJ's internal investigators as a tone-setting conversation that established contempt as the operating framework for the remainder of the stop. What that meant, in plain language, was that Harrow told them about the fake judge, and they laughed. Mullins approached the window first, and he leaned down with the performative patience of a man playing a game, looked at Ellington for a long moment and asked him to explain, slowly, what exactly a federal judge was doing driving around the neighborhood at this hour. The question was not asked in good faith. The slight smile at the corner of his mouth made that clear. Ellington answered it anyway, with the same measured precision he had been deploying since the moment the lights appeared in his mirror. He stated his name, his title, his court, his circuit. He referenced the federal registration on the vehicle. He requested for the 3rd time that someone run the plates or contact a supervisor. Delaney, standing at the rear quarter panel with his arms folded, said something to Mullins that the bodycam audio picked up with unfortunate clarity. "Your Honor," he said, drawing the title out into something that was no longer a title at all. Both men laughed, Harrow back at the driver's window now. He told Ellington that they were going to need him to step out while they sorted this out, as though the sorting were a bureaucratic inconvenience rather than the willful prolonging of an unlawful detention. Ellington did not move. He did not raise his voice. He simply said, with the quiet authority of a man who had presided over hundreds of contempt hearings, that he would not be exiting the vehicle without cause, and that every second of this encounter was being recorded on the vehicle's internal dash system in addition to their own body cams. That last detail landed differently than the rest. A small silence moved through the three officers like a current. Mullins straightened up. Delaney unfolded his arms. Harrow's jaw tightened. It was Delaney almost reluctantly who finally walked back to his patrol car and ran the VIN through the federal database. The return took 40 seconds, and he read the screen once, then read it again. Then he stood very still beside his car for a moment that the body cam footage recorded as lasting exactly 9 seconds. 9 seconds of a man absorbing information that was rapidly rearranging his understanding of the last 20 minutes. He walked back toward the SUV without saying a word. Delaney didn't speak for a long moment. He just stood there at the rear of the SUV, holding his radio loosely at his side, looking at Harrow with an expression that had traveled a significant distance from where it had been 9 minutes ago. The smirk was gone. What replaced it was something closer to the look a man gets when he realizes with absolute clarity that he has been walking confidently in the wrong direction for a very long time. He pulled Harrow aside. The audio picked up fragments: federal judiciary, DOJ registration. It's clean. And it's all clean, delivered in the lowered register of a man trying to contain something that was already too large to contain. Harrow shook his head once, the reflex of someone who had committed too fully to a version of events to abandon it gracefully. Then Delaney showed him the screen. The silence that followed lasted 6 seconds. 6 seconds of Harrow looking at a database return that confirmed without ambiguity or qualification that the vehicle belonged to the United States Department of Justice and was assigned to the chambers of the Honorable Marcus A. Ellington, U.S. District Court Judge, Southern District of Florida. 6 seconds. And then the entire register of the encounter shifted. It did not shift gradually. It shifted the way a power outage shifts a room, total, immediate, and disorienting to everyone in it. Harrow straightened. Mullins took a visible step back from the driver's window. Delaney moved toward the SUV with his palms subtly open now. The aggressive architecture of his body replaced almost comically with something approximating deference. The word "sir," which had not appeared anywhere in the previous 22 minutes of this encounter, suddenly became the only word any of them seemed to own. "Sir, I apologize for the confusion." Harrow's voice had dropped an entire register. The command presence, the wide stance, the hand resting on the belt, all of it had quietly packed up and left. What remained was a man in a uniform trying to locate an exit from a situation he had personally constructed with no exit in mind. Ellington did not respond immediately. He sat exactly as he had been sitting for the entirety of the stop. Both hands visible, posture composed, his expression carrying that same unreadable stillness that had unsettled Harrow from the very first moment. He let the apology sit in the air between them for a beat longer than was comfortable. Then he reached slowly into his breast pocket, retrieved his judicial ID, and placed it on the dashboard facing outward. He looked at all three of them. "I'd like the name and badge number of every officer present," he said, "and I'd like them now." Nobody argued, nobody delayed, nobody reached for a belt or widened a stance or suggested that anything he was holding might be a high-quality fake. They gave him their names, they gave him their badge numbers. They stood at that roadside in the thickening dusk, and they gave him everything he asked for. Because now they understood exactly who was in charge. The call Ellington made from the driver's seat of that SUV lasted 4 minutes and 17 seconds. He did not raise his voice. He did not editorialize or embellish. He recounted the facts of the preceding 22 minutes in the same precise, sequential manner he used when issuing rulings from the bench. Names, badge numbers, timestamps, specific statements made, specific requests denied. The person on the other end of that call was the Deputy Attorney General of the Southern District of Florida, whose personal cell number Ellington had possessed for 6 years and had never, until that evening, needed to use. By 7 a.m. the following morning, the precinct commander had received a formal notice of federal inquiry. By 9 a.m., 3 attorneys from the DOJ's Civil Rights Division had arrived at the precinct with a document preservation order covering all bodycam footage, dispatch logs, MDT records, use of force reports, and internal affairs files going back 5 years. Not just Harrow's files. All of them. The preservation order was broad, deliberately so, because what the Civil Rights Division had suspected for some time, and what Ellington's encounter had now given them, documented, time-stamped, on bodycam verified grounds to pursue, was that Harrow was not an anomaly. He was a pattern, and the precinct was the petri dish in which that pattern had been allowed to grow. What the investigators found, once they began pulling records, was worse than the documentation had suggested. Over a 5-year period, the precinct had generated 340 pretextual stop reports in a 4-square-mile radius that encompassed 3 of the most affluent, predominantly black neighborhoods in the district. Of those 340 stops, 287 had produced no citation, no arrest, no evidence of any criminal activity whatsoever. They had produced, in other words, nothing except the temporary detention of people who had done nothing wrong in places that certain officers had decided they didn't belong. Harrow's name appeared on 41 of those reports, but his name was far from the only one. The internal affairs files were, in their own way, the most damning part of the discovery. On complaint after complaint, many of them filed by attorneys, business owners, and community leaders whose credibility was difficult to dismiss, had been reviewed, logged, and quietly closed without meaningful consequence. The system had not failed accidentally. It had been managed, supervised into dysfunction by a command structure that had decided at some point, and apparently without much debate, that the noise generated by accountability was more trouble than the silence generated by looking away. The DOJ's investigation formally expanded within 2 weeks of the stop, absorbing the precinct's entire field operations division into its scope. The precinct commander was placed on administrative leave pending review. 3 supervisors who had signed off on Harrow's previous complaint dispositions were notified of their status as subjects, not witnesses, in the inquiry. And somewhere in the architecture of all of it, in every pulled file and every preserved log, and every document that the precinct had hoped would never see the light of a federal courtroom, was the image from Harrow's own body cam. A man in a dark suit, both hands on the wheel, waiting. The civil trial lasted 11 days. It did not need to last that long. By the 3rd day, when Harrow's unsealed disciplinary record was entered into evidence, the city's legal team had already begun having quiet conversations in courthouse corridors about numbers. Specifically, about which number was large enough to make this go away, and small enough not to announce to every civil rights attorney in the country that the city was an open target. They never found that number because the record that emerged from those unsealed files made the concept of a quiet settlement feel like wishful thinking. 14 complaints became 22 once the full archive was unsealed. The additional 8 had been administratively buried, not dismissed for lack of merit, not investigated and closed, but buried, routed through a filing protocol that one DOJ attorney described in open court as a paper mechanism designed to ensure that certain complaints never achieved the status of official record. The judge presiding over the civil trial, and the particular irony of a federal judge presiding over a case born from the unlawful detention of another federal judge, was not lost on anyone in that courtroom, allowed the full record into evidence over the city's strenuous objection. What the jury saw over the following days was not the story of one bad stop on one quiet evening. It was the story of a decade. 22 complaints spanning 8 years, each one describing a version of the same encounter in a different location with a different victim. A contractor, a physician, a high school principal, a retired Marine, all of them black, all of them stopped in neighborhoods Harrow had decided required his particular brand of scrutiny, and all of them subjected to the same performative skepticism that had met Judge Ellington's federal credentials with a smirk and a dismissal. The city's defense rested heavily on the argument that Harrow had acted in good faith on a legitimate suspicious vehicle report. That argument did not survive contact with the MDT logs, which showed definitively that Harrow had received a clean federal registration return 7 minutes before initiating the stop. It did not survive the bodycam footage, which the plaintiff's lead attorney played for the jury in its entirety, without narration or editorial commentary, because it required none. And it did not survive the testimony of Harrow himself, who took the stand on day 7 and, under cross-examination, was unable to articulate a single concrete, race-neutral justification for any of the 22 stops in his record. The jury deliberated for 6 hours. They returned a verdict that awarded Judge Marcus Ellington $9 million in compensatory and punitive damages, a number that reflected not just the events of one evening in May, but the full documented weight of everything the precinct had permitted, protected, and perpetuated across an entire decade. Harrow sat at the defense table and stared at the surface in front of him when the verdict was read. He had no expression left to offer. The civil trial lasted 11 days. It did not need to last that long. By the third day, when Harrow's unsealed disciplinary record was entered into evidence, the city's legal team had already begun having quiet conversations in courthouse corridors about numbers, specifically about which number was large enough to make this go away, and small enough not to announce to every civil rights attorney in the country that the city was an open target. They never found that number, and because the record that emerged from those unsealed files made the concept of a quiet settlement feel like wishful thinking. 14 complaints became 22 once the full archive was unsealed. The additional 8 had been administratively buried, not dismissed for lack of merit, not investigated and closed, but buried, routed through a filing protocol that one DOJ attorney described in open court as a paper mechanism designed to ensure that certain complaints never achieved the status of official record. The judge presiding over the civil trial, and the particular irony of a federal judge presiding over a case born from the unlawful detention of another federal judge, was not lost on anyone in that courtroom, allowed the full record into evidence over the city's strenuous objection. What the jury saw over the following days was not the story of one bad stop on one quiet evening. It was the story of a decade, 22 complaints spanning 8 years, each one describing a version of the same encounter in a different location with a different victim. A contractor, a physician, a high school principal, a retired Marine, all of them black, all of them stopped in neighborhoods Harrow had decided required his particular brand of scrutiny, in all of them subjected to the same performative skepticism that had met Judge Ellington's federal credentials with a smirk and a dismissal. The city's defense rested heavily on the argument that Harrow had acted in good faith on a legitimate suspicious vehicle report. That argument did not survive contact with the MDT logs, which showed definitively that Harrow had received a clean federal registration return 7 minutes before initiating the stop. It did not survive the bodycam footage, which the plaintiff's lead attorney played for the jury in its entirety, without narration or editorial commentary, because it required none. And it did not survive the testimony of Harrow himself, who took the stand on day 7 and, under cross-examination, was unable to articulate a single concrete, race-neutral justification for any of the 22 stops in his record. The jury deliberated for 6 hours. They returned a verdict that awarded Judge Marcus Ellington $9 million in compensatory and punitive damages, a number that reflected not just the events of one evening in May, but the full documented weight of everything the precinct had permitted, protected, and perpetuated across an entire decade. Harrow sat at the defense table and stared at the surface in front of him when the verdict was read. He had no expression left to offer. 3 months after the verdict, a Judge Marcus Ellington returned to courtroom 4B on the 4th floor of the federal building and called a case to order. Those who were present that morning, clerks, attorneys, a handful of law students observing from the gallery, noted that he looked the same. Same dark suit, same measured stillness, same unhurried authority with which he had always occupied the elevated space behind that bench. but something had shifted in the quality of his attention, in the way he listened, in the particular weight he gave to certain words when they appeared in testimony or argument before him. The people who knew him best could not have told you exactly what had changed. They could only tell you that something had. He had spent 19 years presiding over cases like his own. Unlawful stops, pretextual searches, the slow institutional violence of a system that had learned to protect itself more reliably than it protected the people it was built to serve. He had ruled on those cases with rigor and consistency, and he had believed, in the way that people who operate from positions of relative safety sometimes believe, that the law was a sufficient answer to the problem, that the correct ruling, properly reasoned and cleanly written, was the thing that moved the needle. He still believed in the law. He believed in it more fiercely now than he ever had. But he no longer believed it was sufficient on its own. He had learned that from a roadside in the early evening, with both hands on a steering wheel, waiting for someone to acknowledge what he already knew to be true. The $9 million did not go into an account. Within 60 days of the verdict, Ellington had established the Ellington Accountability Project, a national registry of pretextual stop data, cross-referenced by precinct, officer, and demographic profile. I designed to make visible the patterns that internal affairs departments had spent years making invisible. It was funded by the settlement. It was staffed, in part, by the attorneys who had represented him. And it was built, in its architecture and its purpose, on the simple and radical premise that sunlight is the only disinfectant that actually works. The precinct did not escape quietly, or the federally mandated overhaul that followed the DOJ investigation dismantled the Field Operations Division entirely, replaced the command structure down to the sergeant level, and installed an independent civilian oversight board with genuine subpoena authority, not advisory capacity, not a suggestion box with a government letterhead, but real, enforceable power to compel testimony and review records. The new policy framework governing pretextual stops was written, at the DOJ's insistence, in consultation with community representatives from the 4 neighborhoods that had absorbed the bulk of them. Daniel Harrow was barred from law enforcement permanently. He appealed. He lost. On Ellington's bench, in the upper corner of the mahogany frame, a clerk had quietly placed a small printed card. It bore no name, no seal, no official designation, just a date. May 11th, 2024, 5:42 p.m. A reminder of the evening the law had to remind itself what it was for.